that recording of further proceedings in the case then and there is not possible, then only, my lord, he has got two options. One is order for a new trial or adjourn the case for some time.
Order new trial.
Order a new trial. My lord, if my lord were to read it carefully, if we were to read it carefully, my lord, it is not in every case where a charge that had already been framed against the accused is altered by an amendment or added by an inclusion, that he gets the right, the court gets the right to pass an order under section 216(4). No. But probably your lordship may have to have a look. Second look at
216.
Yes, my lord.
Yeah.
When he could do it, my lord.
Yes.
See, after such addition and alteration, but if the court is of the opinion that recording of further proceedings in the case then and there is not possible, and if he were to proceed to record further proceedings in the case then and there, it may cause prejudice either to the prosecution or to the defense, then only, my lord, he has got two options. One is order for a new trial or adjourn the case for some time. It is not every addition or alteration that gives him a right or clothes him a right to order for a new trial. He gets, the trial court gets the right under section 216(4) or the power under section 216(4), provided he gives a finding that if I were to proceed to record further proceedings in the case, no sooner such alteration or addition took place, it may cause prejudice. Otherwise, no. But may I just request your lordship to kindly have a cursory look at second look at section 216 subclause 3 first.
Yes.
And then go to subclause 4.
Yes.
So now subclause 3 is if his finding were to be in the negative, that no prejudice is going to be caused. You proceed with the trial of the case as if, my lord, the addition or alteration had come into existence on the date when the original charges came to be framed against the accused. Well, now under section 216 subclause 4, have a look at section 216 subclause 4. If the alteration or addition,
Yes, sir.
well, every alteration or addition does not enable him to
Order new trial.
order a new trial. Well, if my lord were to read it carefully, if we were to read it carefully, my lord, have a look at subclause 4. If the alteration or I'm sorry.
Yes. The only circumstance for a new trial is if there is a finding that there is material change, one. And on the altered charge, the only obligation of the court would be 217 to recall the witness for examination.
That's it, my lord.
That's all.
Otherwise, what is
230, 231 procedure will come.
Yes, my lord, 230 and 231 would come into play. No sooner charges are framed under section 227 and 228.
And
not
now,
otherwise.
if the altered charge has the impact of recommencement of the whole thing, then 230 and 231 will come. That's all.
Otherwise, my lord, the procedure that is contemplated is only under section 217 and not otherwise.
Yes, that is true. Recall of
But
witness.
we have got to read 216 and 217 harmoniously. Now have a look at section 216(4) now.
Yes,
Once again,
Yes.
I'm sorry, my lord, I'm troubling your
problem.
lordship,
Yes,
taking your
yes.
lordship, because every time we keep reading something new would
Always,
occur
that
to
is
us.
always there.
Always would occur
Yes.
to us. If the alteration or addition is such that proceeding immediately with the trial, my lord may kindly underline this, alteration or addition is such that proceeding immediately with the trial is likely in the opinion of the court to prejudice the accused. If the court were to come to the conclusion or were to give an opinion that such alteration or addition is there, it has been made, but proceeding then and there with the trial is likely to cause prejudice either to the prosecution or to the accused, well, then he has two options. That is not the only option. Ordering a new trial is not the only option that is available to the court. The first option is either order for a new trial or adjourn the case. Why, my lord, the court is closed with the power of ordering a new trial or adjourning matter is so that either the prosecution or the defense could keep themselves ready, my lord, to have an effective participation in the trial consequent to the addition or alteration. Not otherwise. Let kindly see, the prosecutor, as aforesaid, the court may either direct a new trial or adjourn the trial for such period as may be necessary. Adjourn it by 15 days. Adjourn it by 1 week, depending upon the evidence with the defense.
Them to get ready with the evidence.
Get ready. That is the main purpose. Well, my lord, it can't be, my lord, under section 230 and 231. At any rate, would be my respectful
Will
submission.
consider.
Otherwise, my lord, what happens is this. My lord, I invited my lord's kind attention the other day.
1 second. Yeah, where is Prasanna Kumar? I'm not granting time. I'm not granting a Passover even. Yes,
He's on his legs.
yes.
My lord, the other day I invited my lord's kind attention to the provisions of section 386, where the appellate court
Bill.
would exercise its powers. My lord, that is also almost akin to section 216 subclass 4. There, my lord, it is the
Power of the appellate
power of the appellate court. But even if, although the appellate court has the power under section 386 subclass 1 to order for a retrial, but the other day I invited my lord's kind attention to the dictionary
dictionary
meaning.
meaning.
What is retrial? What is new trial? What is
De novo
first trial? What is de novo trial? They are almost akin to each other. But there also, my lord, the appellate court cannot blindly or mechanically order for a retrial unless and until, in the opinion of the appellate court, my lord, the trial has proceeded, the judgment of conviction or acquittal is recorded by the trial court. Number one, without jurisdiction. Number two, without adverting to the evidence available on record in the case, my lord, upon extraneous considerations. That is how, my lord, the Supreme Court has said. My lord, a full bench judgment of the Supreme Court. The other day I took your lordship
yes.
to the first judgment of the Supreme Court. My lord, well, now he has exercised his power under section 216 subclass 4. Kindly proceed with an assumption. It has enabled him, irrespective of the fact that a finding that recording of further proceedings in the case then and there may prejudice. No such finding is there. Then and
Yes.
there may prejudice.
Now, one clarification. What is the altered charge?
Well, there is no altered charge at all.
It's what?
I shall submit to your lordship. I was put on trial for an offence under section 302 initially
That is by the state.
by the state upon the investigation which came to be done by the state.
State.
But the altered charge is 302 read with 120B. But originally a charge under section 201 had not been framed at all, which would, according to the prosecution, indicate but either the concealment or destruction of the evidence.
Yes, yes.
A charge came to be framed, an additional charge. But illy, but when I was put on trial for an offence under section 302 to the exclusion of 120B,
Yes.
63 witnesses are examined. But the very same witnesses are cited in the additional charge sheet. Kindly proceed with an assumption for the sake of argument, though not conceding for a moment, though not for the reason indicated under section 216 subclass 4 of the CRPC. The trial judge has the power or the authority or the jurisdiction to order for a new trial.
Yes.
New trial. Ignore a finding not being given that if I were to proceed to record further proceedings in the case, then and there it may cause prejudice to the accused. Kindly ignore that. Next, to the point that is involved in the case, well, imagine the situation. 1 to 6 are eyewitnesses according to the prosecution in the original charge sheet. CWS 1 to 6. Well, they are examined as PWS 1 to 6. For one reason or the other, they might have supported the case of the prosecution or they might not have supported the case of the prosecution. For one reason or the other. The very same 1 to 6 are cited as additional witnesses for the prosecution in the additional report which came to be filed. Likewise, 30 witnesses have been cited who are already examined during the trial of the case. Examined, cross-examined, re-examined, number of documents were got marked through them during the trial at the first instance. Again, the same witnesses.
ನಮ್ಮ ಯೂಟ್ಯೂಬ್ ಚಾನಲ್ ಅನ್ನು ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ ಹಾಗೂ ಫೇಸ್ಬುಕ್ ಮತ್ತು ಇನ್ಸ್ಟಾಗ್ರಾಮ್ ಅನ್ನು ಫಾಲೋ ಮಾಡಿ.